some keywords highlighted here that we'll focus on, but it's any operator or any operator of a commercial website or online service, and that includes like mobile apps or IoT devices that are directed to children under 13, or any operator of a general audience site or service that has actual knowledge that is collecting personal information for children. And let's talk about what that actually means. So for the directed to children standard, to know what FTC has flagged a number of factors to consider. It thinks about the subject matter, the visual content, whether it's animated characters or child-oriented activities on the site, whether there's music, is it playing Baby Shark, presence of celebrities or that appeal to children, what kind of languages are being used, words like silly or is it cute? These are some common languages that the FTC has pointed out in its settlement cases that have come up as sounding child-directed. Advertising, promoting, or appearing on the website or online service. So, like, where are you advertising this product or service? If it's showing up in a child-directed space, then that could weigh in favor of you being considered a site or service that is directed to children. Obviously, also what's showing up within the app itself. Like if you're advertising within the app, indicates that you're speaking to children, trying to get them to to purchase a product, then that is also going to be weigh in favor of that determination. Reliable empirical evidence of audience composition. So if you've done some kind of study and it indicates that you have children under 13 under your site, that would also weigh in favor of being found as being child-directed. And then any other evidence of intended audience, so even an external study. So these are some factors, none of which are determinative on their own. And I mean, as you might predict, it is not as straightforward as, maybe the FTC would might want it to seem. There's a lot of cases where you might have content that appeals to an adult audience that is cartoons, or that might have bright colors. Like using neon doesn't automatically make you fall into a directed to children bucket there. So I think it's important to remember this is a fact-specific scenario, case by case, you should analyze. And then actual knowledge. The other situation where the FTC finds that a site, that someone should comply with COPPA is where the site or service has actual knowledge that it's collecting personal information for children. And it's not a should have known standard, but it's where you actually know because let's say someone has entered in their birth date, or maybe someone has entered their grade level. Those kind of things that let you know that you have children under the age of 13 in your site. I would also say if you're getting lots of emails from parents saying, hey, my kid's on your site and you have records of this and you're continuing to use that data without kicking them off, you also have actual knowledge. So those are just ways that you know that you have actual knowledge. So let's go through a couple of examples. And so in some cases, it's going to be very clear. Like I said, you're going to see Paw Patrol, you're going to know that they're targeting it right off the bat. Brain Pop, something that I use in my classroom all the time. Again, there's language directed to children even throughout the content. And then in some cases, it's not going to be as easy because you have things that may be cartoon-like, but a lot of content may be more adult-like in nature, or you just have a mixed audience using that site as well. And then sometimes the site can change over time. And I have this Hannah Montana as an example here. Back when I was on the internet and the first time like going to Hannah Montana site, it might not be the same site if you entered it in today, just because, she has grown up and her audience has probably grown with her. And then just the reverse can happen. You might have a site that you think is, or you intend to be a adult site, but then, actually based on a study you conducted, I think American Idol was the case similar to this, where, their website is intended to be for adults, but then based on actual data, they found that, it was actually directed to children. what about actual knowledge? And this one is interesting because we talked about actual knowledge earlier in terms of like someone giving you a birth date, or a person, a parent, an adult letting you know that you're collecting personal information from a child under 13. But in the FTC's case against YouTube, the FTC determined, this was in 2019, it was one of major cases, large settlement, 170 million, one of record setting at the time. And the interesting thing about this, for the sake of this example, is that the FTC determined that YouTube had actual knowledge because it was collecting information from children, and then they used their own B2B like advertisements to make their companies, their clients, aware of this. So if you take a look at the box here, you'll see some of the things it was actually saying about itself. It would say things like, YouTube is the new Saturday morning cartoon. YouTube is today's leader in reaching children age 6 through 12, 6 through 11 against top channels. Sorry. YouTube is unanimously voted as the favorite website kids 2 through 12. So all of these things, the things that they were saying about themselves, advertising, promoting themselves, the FTC like weighed that against them, and that's how they were able to like come to that determination that that you had actual knowledge that it was collecting information from children. So next, let's talk about the Epic Games settlement, which is a little bit more recent. And prior to September 19th, players in the United States could sign up to this site, and you may be familiar with it, very popular kid site, and they could sign up with their first name, their last name, display name, and then certain features were turned on by default, like they could communicate with each other in real time by voice and text. And the FTC found that Epic Games had actual knowledge that it was collecting personal information for kids because they were actually responding to player requests. Like many of the kids self-identified as being under 13. They read articles in the news. They identified Fortnite as being popular with children. And then there was internal business documents where folks, employees had identified that there were kids on the platform. The FTC also found that Epic Games was directed to kids under 13 by looking at the following factors. They looked at the subject matter, they looked at the animation, they looked at the child-oriented activities, the music, the content. They had a report, the external study or report that was conducted that showed that 50% of US children aged 10 through 12 played Fortnite weekly. And then one interesting thing is that Fortnite had actual kids merchandise, for Halloween costumes. So all of that, helped tip the scales in favor of them being, determined as directed to children. So your next step, if you determine that you passed the first threshold and that you are in fact, directed to children, and you therefore may be on the road to having to comply with COPPA. Before you do that, I think it's important to know, am I collecting the type of data that is covered by COPPA? And so the examples from the SPC here, it is not exhaustive, but some of these are like very easy to determine. You have like direct identifiers like first name and last name, your home, physical address. You have online contact information, social security number. I think those are the no-brainers. Some are new since the 2013 amendment to address like behavioral advertising. You have persistent identifier that can be used to recognize a user across time and over time and across different websites and online services. Photo, video, audio file, precise geolocation, sufficient to identify street name or city of a town, and a screen name that you could use to contact someone. So if you can also like reach out to someone via that screen name, that is also going to be considered personal information. This is a difference, again, that we're seeing with the newer privacy legislation that's being proposed and enacted, where in this case, COPPA applies if you're actually collecting information from a child under 13. So not if a parent or an adult is entering the information about the child. It also doesn't apply in cases where website or service is just likely to be accessed by a child, but is not collecting personal information. So I think those are two important distinctions to make in this landscape. So what do you do if you are covered by COPPA? So first, you're going to need to post a COPPA compliant privacy policy. And I think you might find that your general website privacy policy may already check a lot of these boxes, but it is very much worth going through and doing a check to make sure. If you look at the COPPA FAQs, it has exactly what's there and what's required, but that's one of the first steps. The next step you'll want to do is make sure you have a direct notice to parents before collecting their personal information. And a direct notice is separate and apart from the privacy policy. It's not the same thing. And it also must include very specific personal information. I'll just read off some of the examples of what must be in there. You must state that the operator has collected the parent's online contact information from the child, and you have to say that you've gotten their information from their kid in order to obtain parental consent. You need to let them know that consent is required for the collection, use, and sharing of the personal information. You need to set forth additional terms of personal information, additional items of personal information that you intend to collect, so they know what you're actually going to collect and what you're going to do with it. You have to include a hyperlink to your privacy policy, and you have to state that if a parent does not give that consent, then you will delete the parent's online contact information from their records. So I read all of those off just because it's not a check. It is not a thing where you could just simply say, oh, I'll just link to my privacy policy for the direct notice. It has to meet specific requirements. The next thing you have to do is obtain verifiable parental consent. That kind of ties in with the notice of parental consent before collecting personal information from kids. And we'll talk about this in a second, but it can't be something passive. Like, you can't just say, oh, by accessing this site, you agree to our privacy policy. I think that language would fall short of, well, it definitely would fall short of the verifiable parental consent requirement. You'll have to also honor parental rights with respect to the personal information collected to kids. They have a right to review. They have a right to delete information. They have a right to keep your information being further processed. These all are rights that you have to be prepared to operationalize. COPPA also requires you to maintain reasonable security methods. And finally, you have requirements around data minimization and retention, where you can only keep personal information for as long as necessary, and to delete it, make sure it's adequately deleted to a certain standard, and you cannot use that information indefinitely. So let's talk about this verifiable parental consent requirement a little bit here, because this is not easy to do. It's actually pretty costly, and I think if you're looking at the items here, the common ways here, you'll see they're a little outdated. So the first one, can get a consent form signed by the parent or legal guardian, and they can return that by mail or fax. You can have, I would say the credit card, debit card option is the most common. And I think that the premise or the theory behind that is that if the person has a credit card, they're over 13. And also, whenever someone swipes their credit card, there's a record that, a purchase was made. That poses challenges in our space a little, because, some folks don't want to tie it to their product or service to a credit card as soon as they get started, because it's a startup and they want as many people to use the product or service as possible. So that's one of the challenges that we see with making that the consent method. A toll-free number that parents can call, again, that requires your training, employee training, having someone able to actually do that. A video conference, a government-issued ID, Email Plus, and knowledge-based authentication. I will start your Email Plus, because Email Plus is an easier route to go. It is something that you can use where you can email to get a parent's consent and provide a confirmation, but this exception can only be used where that information is not further disclosed to third parties. And examples of that is not just third parties like you would, to other businesses that might use it under commercial purposes. That, of course, is not allowed. But what's also not allowed is if you have like any kind of chat or open message features, that's going to be something where that information is getting disseminated to others outside of your internal business. That's still going to take you out of being able to use that more simpler email plus option. So those are all things to consider, and it's really interesting to see like the proposals in this space of what has been proposed and what's been how folks are contemplating dealing with this in the future. So importantly, there are exceptions to the verifiable consent requirement. And so what I've seen typically with our clients, we try to, unless it's absolutely needed for the product or service, we try to think about whether an exception might work. And here's some common exceptions. You have to request the parental consent, of course. You're allowed to collect enough information to do that. You can also use personal information for one-time requests, like a child-directed, like a sweepstakes directed to a child. Ongoing or multiple contacts strictly lists links to online contact information. So think a newsletter here, and you can't use that information for any other purposes, though. You could only use that content information to send that content to the child. To protect the safety of the child, to comply with legal obligations, those are pretty straightforward. I think you see those exceptions in most laws, but the most useful and interesting one, I would say, in the EdTech space is for the collection and use of a persistent identifier that is used to support the internal operations of a site or service. So I think this is very helpful for the EdTech companies because the COPPA rule defines internal operations as activities necessary to maintain or analyze the site or service's functioning, perform network communications, serve contextual advertisement, authenticate the site or service's users, provide user-driven personalization, to protect the security of the user, the website or service, to ensure legal compliance, and to fulfill the child's request under the one-time contact or multiple contact exception. So if you are using that personal information for solely internal to support the internal operations of your site or services, then that gets you out of the requirement of having to provide that verifiable parental consent. Delivering behavioral advertising, of course, would not be considered an internal operations. So let's get to a part that is probably most interesting for today's discussion, given the kind of products and services you're offering. How does this all apply and look in schools? So I was looking, in preparation for this, I was looking back through some of the old FTC guidance and blog posts, and I saw one from 2015 who pretty much, it was a statement from the FTC saying, this issue about how do we go about this requirement about getting consent from parents in the school context is not new. And when you think about it, like as a teacher, having to get consent for each and every student is quite difficult. I mean, I can remember trying to get permission slips, and it was a challenge to me to make sure I can get all those back, and that was for things that were fun. And sometimes, just to get students to do things that were required, even if it is EdTech, sometimes it is not as easy to get those permission slips back. So the FTC actually contemplated this, and this was in their statement of purpose that accompanied the original COPPA rule. I will say that this is the preamble to the rule itself. It's not in the actual rule. And I think it's worth kind of reading the text here to get some insight about the guidance that they're providing in this case of consent in the school environment. So they said the rule, that the FTC notes the rule does not preclude schools from acting as intermediaries between operators and parents in the notice and consent process. So that's one option. Schools can be intermediaries, or from serving as a parent's agent in the process, so standing in the parent's shoes. So for example, schools may already seek parental consent in school internet access at the beginning of the year. So we can, so there were an operator is authorized by a school to collect personal information from children after providing notice to the school of the operator's collection, use, and disclosure practices. The operator can presume that the school's authorization is based on the schools having obtained the parent's consent. So I think that here is a very practical one. It keeps the school or the teacher from having to go individual by individual, making sure that the EdTech company has that consent. Yeah. So just to dive in a little deeper, the COPPA FAQs, and if you see in the back of this slide, the last line of this slide, it says, to ensure the implementation of the rule, the FTC intends to provide guidance. And the guidance that we received is in the form of the FAQs. And so one of the questions was, can schools consent to a website or app collection of or use of personal information from students? And the answer is yes. If an operator is an online program solely operating for the benefit of the student and the school can act as the parent agent and can provide that consent in that circumstance. So the benefit here has to be for the students in the school. It cannot be for other commercial purposes. And then the operator must continue to meet all those other requirements that we talked about earlier. You still have to provide the direct notice. You still have to have the reasonable security measures. You still have to do all those things that COPPA requires. Just because you're getting the consent from the school who's standing in the shoes of the parents, those obligations do not end. The FAQs also have a lot of best practices around what who consent can be obtained from, what that consent should look like. Those are things that are also in the FAQs, and I encourage you to look at those in full, but here are a few. They recommend obtaining consent from the school rather than teacher. I think it's noteworthy that there's nothing in there prohibiting obtaining that consent from the teacher. And I think we can probably understand what the rationale for that preference, right? Because the school's going to have a better idea of the policies in place of making sure that it's consistently enforced. Sometimes a teacher might just like click yes or try to adopt something without fully thinking of the big picture. So that is something there that the preference there makes sense from the FTC. Providing parents with notice of the technology for which it consented is also a best practice. So just because you gave the school notice, the FTC still says the best practice is to still make sure the parents has that notice as well. Having a contract in place with the operator and that's where you're going to have all the requirements that you are doing all those things under COPPA that you said you would do. And then you want to make sure that the ability to comply with any of the rights requests that you receive from the school to review, correct. All those obligations are still in place. The next question, I guess, obviously leads is, well, what happens if you're trying to use personal information in a way that is not solely for the benefit of students? And in that case, the FAQs make it clear that the operator will need to obtain parental consent and still meet all other COPPA requirements. I think Jim is going to delve in deeply here with the Edmodo decision, but important to flag, like, what does that look like? Is it you going straight to the parent? Is it you going through the intermediary? If you do go through the intermediary, there's obviously going to be challenges there, record keeping track of that consent, to show that you can use that information for that purposes when you're going through an intermediary. All those sound like are like logistical challenges. Most of the folks we work with go with the using the school, using the information solely for the benefit of students. But there are times where you may need to go outside of that. In those cases, be prepared to get the parental consent. So now shifting gears a little bit here, the first law, COPPA, we looked at applies to operators of websites and online services, so EdTech vendors directly. And Now we're shifting gears to FERPA, the Family Educational Rights and Privacy Act, which is geared towards or applies to schools that receive federal funding. This is a much older law enacted in 1974. It prohibits a school from disclosing personally identifiable information from a student's education records to a third party without the consent of a parent, unless an exception applies. It provides parents the right to inspect and correct the information that's found in their records. It provides parents the right to make sure their information is also kept secure. And then finally, it's important to note that these rights transfer to the student when the student turns 18 or enters a secondary education or higher ed, so at any age. The U.S. Department of Education enforces FERPA, and the penalties are such that schools can lose their federal funding, and then schools can be banned from using a vendor for 5 years. And so through those penalties, through your work with the schools, I think it's important to note that even though we stated that FERPA applies to educational agencies and institutions that receive federal funding, high schools, middle schools, all of those, it doesn't mean that, EdTech vendors are off the hook. You still are subject because that information you're receiving is still FERPA protected. And in order to use that information or get it disclosed to you, we'll talk about this a little bit later, it's often disclosed through something called the school official exception. And when you disclose information under that school official exception, it can only be used for certain limited purposes. So let's take a deeper look at the kinds of information or data that FERPA protects. And as I said earlier, education records are those records that are directly related to a student, maintained by a school. I think when this was first created, FERPA, they imagine like literal file cabinets, the maintained by the school piece. But now, obviously, when something's maintained by a school, it might be maintained by an EdTech provider holding it on their behalf. But that was the idea originally. Personally identifiable information within that education record. Here is the examples and definitions here. You have the direct identifiers like name, address, the student's family member's name, social security number, biometric records, and then it also includes indirect identifiers like birth date, location, and your mother's maiden name. And then there's this interesting addition to the definition, which might sweep in more information than you would expect. Other information that alone or in combination is linked or linkable to a specific student that will allow a reasonable person in the school community who doesn't have knowledge of the relevant circumstances to identify that student with reasonable certainty. So that is an example. So you could think about how something alone on its own might not be personal information, but because you're able to tie that to a student or link it in some way, then it could present more information that way. And then directory information. Directory information is something that that is contained in an education record that would not generally be harmful if disclosed. So examples are student name, address, telephone number, date of birth, honors, awards, clubs, sports, dates of attendance. Think anything that you would put in a yearbook, just in a directory. That's what would be considered directory information. But I think it's important to note here that just because this is the list of what's considered directory information, this is something that schools have to, take upon themselves and establish as directory information and notify parents and saying, this is what we consider directory information and it will be shared publicly. And then schools also have to provide a way for parents to opt out of that sharing. And I think that is one of the reasons why, this exceptions from the requirement to get parental consent may not be leveraged as much because sometimes that ability to opt out is not feasible depending on your product or service. So what's not covered? If you use de-identified information, which means you're removing all personally identifiable information, and then you're making sure that you can make a reasonable determination that the student's identity is not personally identifiable, then you can use that information. But I think with all privacy laws, you should make sure that you're meeting a certain high standard of making sure that that information can't be re-identified before you use it. So that's watch out. It's very useful there. You can use analytics or make high-level determinations about the data, but then also know that, you want to make sure that folks can't be re-identified. So we already been teasing up the FERPA school official exception and the directory information exception, of course, but there are other exceptions as well. I put some that might be relevant here. FERPA permits disclosures for financial aid purposes, educational research, accreditation, health and safety, which makes sense in health and safety emergencies or for treatment purposes. You can just make certain disclosures. A lot of these exceptions come with their own sub-requirements, so important to flag that. But for the purposes of our discussion here today, we're going to focus on the school official exception. And so FERPA specifically permits school officials to use that personal information for their legitimate educational interests. And under the Department of Education regulations, educational service providers fall under that school officials exceptions when they meet certain requirements. So what are those requirements? In order to meet those requirements, you must perform an institutional service or function for which the school would otherwise use its own employees. So if you're, a grading book, or if you're providing a teaching opportunity, all those things would be something the school would do itself. You are under the direct control of the agency or institution with respect to the use and maintenance of education records. And we'll talk a little bit more about that shortly. You meet the criteria of specified in the local educational agencies or the school district annual notification of FERPA rights of being a school official with a legitimate educational interest. And of having a legitimate educational interest is not obviously commercial. It's something that aligns with either just fulfilling the product or service that the school needs, fulfilling an educational purpose, and then using educational records only for the purposes authorized and not redisclosing it to third parties or others unless you have specific consent from the school or otherwise permitted to FERPA in one of those other exceptions we mentioned, like the law enforcement exception. So those are the restrictions you have on using that data. I want to highlight something that the Department of Education has put a lot of emphasis on, that direct control piece. Something I said earlier, that the data still belongs to the school. And you need to, and as an EdTech provider, you'll be thinking about how can you demonstrate or show that the school has that control. And one of the ways that you can do that is via contract. You'll see language to that effect in the contract. You might say, I'm providing service on behalf of the school. Another way that you make sure that the school has that direct control is by making sure that they can fulfill their obligations under FERPA by being able to provide parents and eligible students with access to their data. So it's not a good scenario if they have these obligations under FERPA and can't get the information they need from their EdTech provider to give students access. So that is something that the Department of Education has placed a lot of emphasis on, and something that you should think about in helping your schools meet their FERPA obligations. So what does this mean for EdTech vendors? So FERPA, like I said, keep saying FERPA governs the use of the PI that you obtain from schools. They're still responsible for it, even though they're handing it over to you. EdTech vendors must limit the data collection to only what's necessary to provide the services. They must ensure that schools maintain direct control over that data and do not use it for any reason outside of the legitimate educational purposes for which it was provided, to not disclose the data to third party without direction from and consent from the school, and then maintain appropriate reasonable security measures. I think the thing to flag here with the security piece is, FERPA doesn't have like a specific NIST requirement. You need a certain requirements of security, but if there's an unauthorized disclosure, that is in violation of FERPA because you are not supposed to be sharing this information without the added consent pass. So that's how it all kind of ties in together. What does the future look like? And sometimes I think a good way to look at the future is to look back to the past, the recent past in this case. We're going to look at think about two COPPA cases that recently came up. One was in March 2022. It was where the FTC announced a settlement with a company formerly known as Weight Watchers, and its subsidiary Curbo, for violating COPPA for collecting personal information without parental permission. Here's a screenshot of the app. You can see that it's about wellness. I think they allowed kids to put in information like their name, contact information, those basic direct identifiers, but also like tracking their weight loss. So those were potentially sensitive pieces of information. When you get on the edge of health, it's a hot topic. But the FTC complaint said the sign up process encouraged kids to falsely put in the wrong age or not say that they were older than they were to gain access to the site, and therefore the consent wasn't valid. And then also the FTC said that Curbo failed to meet the COPPA's notice requirements and the data retention provisions. They held onto the data indefinitely. The significant part of the case to note is that they were required to not only delete all of the data that was illegally obtained, like from children who were under 13 without parental consent, they were also required to delete the algorithms. So anything that informed, any data that informed those algorithms and the algorithms themselves, where they were required to delete. And I think this is the first time we've seen this from the FTC in a COPPA settlement. And so in addition to monetary fines, compliance reporting, this is a measure that's really intended to really, I think, hit companies hard. And you could think about what it might mean in terms of risk to your business if you had to do something like this. We work with an AI app, and to think about it from that perspective, where you have a child learning app and it's helping you to read, and it's being informed by the past interactions, to have to delete all that data could be detrimental to your business. So that is something that you think about when you're thinking about how you structure your product itself, and also how you can mitigate risk from making sure that you're COPPA compliant. Let's look at the next case, Epic. So this is another more recent case against Epic Games, the company who owns Fortnite. We highlighted a little bit earlier, but it raised some really interesting questions about COPPA, privacy, and teens. So I think the thing to note here is that I have the future of COPPA enforcement as the title here, but it's a little bit of a misnomer in the case of Fortnite for teen situations. But it's interesting here that didn't necessarily expand COPPA's scope, but it required Epic to implement privacy protections for teens as well as children. It required the game makers to obtain affirmative express consent from a child's parent or from either the teen or himself to participate in the features. So this was the first time that the FTC enforced the teen privacy protections in a case under the Section 5 of the FTC Act authorities of unfair and deceptive practices. And the FTC argued that this on by default, all the time, like real-time voice chat settings could lead to real psychological harm to children, and by exposing them to bullying, threats, and traumatic issues while talking to strangers. So we could see the FTC kind of expanding its authority there in making rules around teens. With future COPPA, what can we look forward to in terms of from a federal development, a legislative development kind of aspect here? And I know this is probably going to be talking more later today, but just to highlight, there's been several proposals, at the federal level that reflect what we've been seeing globally. Like we've been seeing proposals where you're upping the age of protection, again, from not just all the way to 13, but to 16 or 18, giving children, not just parents, more control of their data. So thinking about what that might look like in terms of, well, what is in the best interest of a child? And then expanding the definition of personal information. So these are some kind of things that we've seen, and some two bills to flag is the Children and Teens Online Privacy Protection Act, or COPPA 2.0, which would extend privacy protections to minors from 12 to 16. It would, it would prohibit websites and online services from collecting personal information without notice and consent. It would set certain data security standards. Then you have COSA, the Kids Online Safety Act, and this one is more harm-based, and it's kind of what I was saying earlier, where you would have requirements to protect the best interests of the kid. And then the last thing before I wrap up, we'll talk about the FTC's policy statement. This was published in 2022, and this was kind of gives us an idea of how seriously the FTC is taking, compliance with COPPA, EdTech. This is something that they really are looking to enforce aggressively on. And we know that because on May 2022, the FTC unanimously voted to adopt this policy statement, and they promised to scrutinize compliance with the full breadth of the substantive provisions of COPPA rule and statutory language, with a particular focus on protecting children who are required to use certain technology to complete schoolwork. So some of the things that the FTC will focus on is the prohibition against mandatory collections. You cannot require children to provide more information that is reasonably necessary for the participation in the activity. You cannot use personal information collected from a child with the school's authorization for other commercial purposes. So that's a use prohibition there. You can use it for marketing or advertising. And then you cannot retain children's personal information for longer than necessary to fulfill the original collection purpose. And thinking back to the Curbo case we just mentioned, and how they kept the information indefinitely, you should only use it as long as you need it. And then finally, the reasonable security requirements. You want to make sure that you're doing everything you can to maintain the confidentiality, security, integrity, and of children's personal information. And so I'll just end with this quote here that I think it just resonates with how as much we should be paying attention to this issue. So in case an EdTech company is thinking about passing compliance off to schools, parents, or others, even like the contract provisions of terms of service, the policy statement makes it clear that that's a hard no. The responsibility to implement strong privacy protections rests squarely on EdTech companies, and it's an obligation they can't shirk. And so with that, I think we have time for questions.
So we're going to skip on questions for now and move straight to Jim's, just to be conscious of time. Thank you so much, Shonda.
Oh, no problem. Thank you so much. Sorry, I was just trying to catch up with the chat.
Right. Good morning and good afternoon to everyone. Looking forward to talking with you. My name is Jim Siegel. I'm a senior technologist here at FPF, and for nearly 2 decades before that, I was the technology architect for Fairfax County Public Schools, a very large school district in the DC area. So working as a practitioner and dealing with a lot of FERPA and COPPA questions. And we're going to be talking today about the recent FTC Edmodo decision. So kind of continuing on with the COPPA conversation, but some practical applications. So as Chandra wonderfully set up for me, thinking about COPPA in the education context, it really leverages off of COPPA's existing verifiable parental consent. But this is really an area that has always been a huge gray area. So with verifiable parental consent, with COPPA, the biggest requirements as COPPA has is the direct notice, as Chandra mentioned. So making reasonable efforts to make sure that they receive the direct notice. and a number of other things. I loved it that Chandra pulled up the same piece that I always go to, which is this statement from the 1999 Federal Register. This is literally the only place that there is any kind of allusion to how schools and their role in COPPA. Really, the two things here often get conflated as one thing. So the statement really talks about acting as intermediaries between operators and parents, and or serving as the parent's agent. And one of the biggest challenges in the guidance is often the FTC guidance conflates these two, and sometimes I see this conflated in school districts' understandings and in EdTech companies' privacy policy. So really, two very different things are at the heart of the Edmodo settlement. Schools can act as the parent's agent, and they can act as intermediaries. Those are two different situations. So just to recap, the school's ability to consent, that act as the parent agent, is only where there's an educational context and no commercial use. And if there is a commercial use, then the school can act as the agent, and they either have to be an intermediary or they have to get consent directly from the parent. So when the FTC brought a suit against Edmodo, a learning management company that, like many companies, had two business models. They sold directly to schools and districts under contract and licenses, and they had a freemium model where they marketed directly to teachers for free to create accounts to generate demand. Two very different business models that we see in EdTech today. And often those are representative of the two different kind of pillars of COPPA. So the Edmodo complaint talks about those two scenarios, and really one scenario where Edmodo was acting as the parent's agent, and each case had three areas of concern. One, that Edmodo tried to shift COPPA compliance onto the school, and COPPA, as we just heard, is a law that applies to vendors as opposed to FERPA, which is a law that applies to schools. So there is no COPPA compliance liability for schools. It's a strict liability for vendors, commercial entities that COPPA applies to. It also said that they didn't provide that essential direct notice, which is, as Chandra mentioned, is not the same thing as the privacy policy. It's a very specific type of notice that talks about information practices. And really, where this all broke down was that regardless of any attempts to have the school act as the parent's agent, Edmodo had a business practice of providing contextual ads, and they made money from contextual ads. And that was a commercial use of the application that voided the school's ability to act as the parent agent, because there was a commercial use that was not part of the educational context. So really, it put it immediately into the other case, which is the schools couldn't act as the agent. So they looked at the case and had a separate claim for where Edmodo was relying on schools and teachers to act as the intermediary. And there were 3 points there. They failed to inform the schools and teachers about their role. They failed to make reasonable efforts that the parents received that direct notice, which is that COPPA requirement. And they failed to verify that schools had actually obtained consent. And really, the biggest takeaway from the Edmodo decision for me is that while it shored up some things and answered some questions that have been unresolved for 23 years about this vague topic of school as the parent's agent, it didn't clear up anything about this second case of schools acting as an intermediary. One of the biggest things, and I mention this because this is something that I used to see all the time in privacy policies. And there's still about, if you Google this exact term, there are about 900 privacy policies from companies that have this exact language. And the issue was that first intro line that says, if you're a school, you represent that you are solely responsible for complying with COPPA. And as we just said, that schools can't be responsible for COPPA. So this was a view that Edmodo was trying to shift the compliance for complying with COPPA off onto the schools, which is not permitted. We're going to come back to this one in a second after we look at what the actual Edmodo settlement and requirements were. So the settlement was a monetary penalty of $6 million, and it was suspended because Edmodo ceased doing business in the US during the course of the lawsuit. They were bought out, I believe, in about 2018 by a Chinese company, and they no longer do business in the US. Some of the things that were very notable about this settlement is that they were banned from using schools as an intermediary in the verifiable consent process. They were, if they were to ever resume doing business in the US, they would be required to obtain school authorization in a very specific way. They, like many FTC decisions, they were required to adhere to a retention schedule. They had reporting and record keeping requirements. And as Sandra mentioned with the Curbo settlement, the penalty also included a requirement for what's called algorithmic disgorgement. They had to delete algorithms and models that they've developed using the personal information that was collected without authorization. So the key thing about the parent agent, the schools acting as the parent agent, was this is the first time that we have seen any somewhat clear guidance. And again, settlements only apply specifically to Edmodo, but we can take some guidance from this. So the school would be, if Edmodo were to do business in the US again, there was a specific requirement for them to enter into a written agreement, a contract, a data protection agreement, as we've seen a lot in K-12 in the last 7 or 8 years. And then we're going to be talking about later on this afternoon. That the school is the parent agent, that they're providing information for educational purposes, for describing how the information is collected, requiring that very clear delivery of the online privacy notice, and verifying that the person that is providing that consent actually has the authority to do that from the school, in the same way that they're responsible for confirming that the parent is the parent. So if you think about all of those things, they're really the same types of things that were listed in Edmodo's privacy policy, this 1 through 5. And it would have been fine if they had been not saying that the school was responsible for complying with COPPA. And I think that's a really important takeaway from this, that red flag of shifting responsibility for the school versus these other 5 things. These were the same 5 things that the FTC required that Edmodo do if they were to ever work with schools as a parent agent. I really want to highlight this importance of this COPPA direct notice. Here's one that I've been using as an example. Classcraft, which was recently bought by HMH, have a really good, clear COPPA direct notice. The other thing, as a former practitioner, as a school person, that I really like about this is that they also have a link to their data collection schedule. It's really detailed and very clear about what kinds of information they collect and how they use it. And I think it's a very good, clear exemplar of a direct notice and that data schedule information that's definitely worth passing on and highlighting. And as I mentioned, there were some really good things for clarity in the Edmodo decision about what you have to do when you're contracting, when the school is acting as the parent's agent. I think as I mentioned, the biggest takeaway is there is still no clear guidance around what would be an approved method for a school to act as the intermediary. There is no guidance. The only thing that the decision says is that Edmodo was at fault because they didn't follow up with the schools to see that they had to verify that they had notified the parents and verify that they had collected the verifiable parental consent. And I think there's a fundamental flaw in the idea of schools acting as an intermediary, especially the way that many EdTech vendors implement it by providing an example of a permission slip and saying that you're required to keep these forms. Intermediary, pretty much by the definition of the word, involves being an intermediary, moving something from one place to another and not holding on to it. I think we probably all agree that if the post office held on to the letter and only produced the letter upon request of the person that sent it, they'd be a pretty bad intermediary. So I think this really kind of changes how schools and EdTech vendors need to think about that role that many schools, many EdTech vendors and their business models rely on, with schools acting as the intermediary. So in terms of what you can take away for this, really want to emphasize the point that direct notice is now even more important than it has been. It's really something that the FTC has said is essential for establishing COPPA compliance when you're relying on the school to provide consent. It means that school contracts and data protection agreements, like we'll talk about this afternoon, are even more important. I think it's definitely going to have an impact to the freemium model. It's very clear that the FTC is kind of on the lookout for language in privacy policies that imply that the EdTech company is trying to pass COPPA compliance on the school. And I think lastly, because the last 8 or 9 years of state level student privacy laws have really put us and conditioned us to pay attention to looking for targeted advertising, we haven't paid as much attention to contextual advertising. And the Edmodo settlement really highlights how contextual advertising is significant in that it will void the school's ability to act as the parent's agent. So I want to just stop there, and we are at time for our break. I want to check in with my FPF colleagues and see if we have any leeway to take a question or two. Looks like we had one question in the chat. So Elizabeth or Alexa, can you let me know whether I have the ability and time to answer a question?
Yes, there's one question in the Q&A, and you're welcome to answer it.
Great. So the question was, how does Edmodo impact the scenario where vendors collect PI about the student from the school and not directly the student? Oh, this is a great question. So if you kind of think back to Chandra's presentation about COPPA, COPPA only applies to data collected directly from a child, or a known child, or a likely child based on the site. So COPPA wouldn't apply in this case. So if the data is being collected directly from the school and not the student, COPPA is not in play. Now, when I tested every single application that came into my school district, I was always very skeptical and wanted to make sure that there was no case where the data was being collected, where the student would be involved. But certainly think about something like an application that is for administrative use and only being used by the teacher. That might apply. A lot of times you really need to think, like, for example, you might think a gradebook application might not, you might think of that as something that only the teacher's entering information. But when we think about, data collection, there could be data collection if this, obviously a student is going to have a login to a gradebook. It's going to be protected. So it is collecting other kinds of information, certainly likely going to collect an email address. It's going to collect metadata. It's going to collect other kinds of telemetry. So that might really need to think about the details and maybe peel back. I think some of these other questions, and in the interest of time, and I'm standing between you and lunch, I believe that I'm the first panel after lunch, and we're going to be talking about privacy policy. So we may be able to get to some of these in that panel, but I'll also answer these by typing in the answer. So you'll have that when you come back for lunch. And with that, I'll turn it back to Elizabeth and Alexa.
Yes, so we can now break for lunch. Please return here at 12:45 so that we can begin the next session on privacy policies.
Hello, everyone. Welcome back. I hope you got a quick lunch in. Without further ado, we would like to start off with our next panels. First, today, we are going to hear about privacy policies, and then we are going to talk a little bit more about the role of contracts. So we are going to kick things off to our panelists for privacy policies, Jim Siegel and Melissa Tebenkamp.
Good afternoon, everyone, and welcome back. Looking forward to digging into, if not my favorite topic, certainly a topic that I spend a lot of time dealing with. I'm one of the people that review the privacy policies for the Student Privacy Pledge, and I think this year I've probably looked at about 150 privacy policies. So I'm here today with Melissa Tebenkamp, just one of my favorite experts in the field when I think about student data privacy and data governance. I'll have her briefly introduce herself. You'll hear from her later in the next panel. And we've got really three big questions to talk about for privacy policies, and want to leave a little bit of time for questions. So Melissa, why don't you introduce yourself to folks?
Well, thank you, Jen. I am Melissa Tebenkamp. I had just recently transitioned out of my role as a Chief Information Officer for a school district from the past 17 years. So since 2006, I filled that role. And I've done a lot of work in the data privacy space. I'm like Jim, I love privacy policy work and contracts. That's one thing that I know many people think maybe a little odd, but I really do enjoy the work around our student data privacy. And that comes with privacy policies and the legal aspects of the contracts. And so I will be part of the next session as well. But it's been great being in this field for sure.
Great. So I'm gonna kind of start by framing some of the things that I've seen in looking at a number of the pledge privacy policies, and then kind of get your thoughts. So in thinking about the privacy pledge and some of the common clauses that I see that often cause challenges, I would say two of the most common, I think, are around how material changes to the privacy policy and to the vendor's practices are notified, and how that's communicated. And I think we'll probably get into this in thinking about this kind of tension between a privacy policy, which is also often feels more consumer or end user focused, and the topic that we'll be dealing with in the next session in contracts. And then the other one around also about control, around change of ownership. One of the things that I've seen really in the last 3 years, and probably no surprise to anyone that's tracked the EdTech industry, is there have been a lot of acquisitions. This has been the case for quite some time, but many of the vendors that we had on the pledge have been acquired by other companies. So thinking about that as something that is clear in privacy policy is important. I know you had a particular strong take about privacy policies and contracting when you were at Raytown, but also you provide a lot of guidance through teaching through COSA and your other work. What are some of the things that you counsel the districts that you work with when they're looking at privacy policies, how to look at a privacy policy, how to read, what is the job of a privacy policy?
So the job of a privacy policy is really to talk about what we're doing with data and what they're doing with data and what those expectations are. And, you know, when I talk to my teachers, and I'm going to take it all the way down to the entry level of my teachers looking at resources, I teach them to do a control F and find certain language just to be keywords of what is happening with our data. We look at if we're talking about a minimum student age and the age of 13 and the use of the data, or the use of who can consent or who can use the service, what data is being collected, we look for COPPA and whether or not that word is in the privacy policy and parental consent. And I think a lot of those words you've already spoken to over the today, but where I find that there are some confusion with privacy policy, and then what we end up doing with a data governance addendum, and we'll talk a little bit about contracting. So if I need to pause, you let me know. But is that I'll often read in a privacy policy that, you know, that parental consent is needed for students under the age of 13, but then the company is willing to sign a data governance addendum designating them as a school official, and that they're not going to do certain things with my data, but yet they want parental consent for my kids under the age of 13. And I think talking to schools about the contract language and the privacy policy, and then the data governance addendum that is signed, or the data governance agreement that is signed, and making sure that there's consistency between those, there are no conflicts, but also that it's fully understood what is being collected and how data is being used. And I think that that's a big piece of reading that privacy policy and making sure that there's, you know, that everybody is speaking the same language and is in full understanding.
I love that you brought up that school official part. One of the things when I do something very similar, I look for certain terms. One of the things that I always do is I tend to take I take 3 sentences at random in the privacy policy, and I put them into, pick your favorite search engine here, and put them in quotes and look for that text, because I think it's fair to say that I've probably seen about the same amount of plagiarism in privacy policies as I would see when I was in my district and like looking, you know, at 9th grade English papers. And I think it's really just, you know, an indicator of if that language is actually what's going on. So your point about the privacy policy as a way, as a resume, as a way of, you know, saying this is what the application does. And one of my flags has always been, you know, is the privacy policy declaring that they are a school official? Because I think in our section this morning on FERPA, that is the district's job. Only the district can declare, you know, a vendor, a school official, and we'll talk a little bit more about that in a second. There was something in the questions that I'll get back to at the end, but at its heart, it was really asking about resources. This one was related to COPPA and nonprofits, but there are some. This has been a conversation for years. There's been some great work that we did together at COSN. What are some of your kind of go-to resources for getting smart in this area around privacy policies?
I think that now there are so many more resources out there than when I got started, and the creation of those have been so necessary. COSN has great resources out there on student data privacy and the policies that schools have and the compliance side. The U.S. Department of Ed has some great resources out there. They have model terms of service, which I think Jim knew I was going to say that.
Can you tell we've worked together for a while?
Worked a lot, and then the Future of Privacy Student Privacy Compass, is that the right one? You guys have lots of great resources out there. The model terms of service is what I typically use when I'm working with a vendor and we are going back and forth and we're stuck on some language, usually around school official, usually either school official, I should say, or the use of data for marketing purposes. And one thing that I have seen is even with companies who have signed the pledge, which, by the way, kudos to you if you have committed to that, but oftentimes, companies switch legal counsel or they bring somebody new in, and that person will review and revise and update policies, and we have to make sure that that there's not a conflict, there's not a change there that goes against the nature of where the company really is with data privacy. I've worked with, through just contract negotiations, I've worked with some companies whose attorney did a really great job of mitigating a lot of risk and liability, but completely contradicted what they signed on to in the pledge with revisions in their privacy policy in terms of service. And so just making sure that everybody is on the same page and they understand the model terms, why schools need certain language in those components, but also as the organization develops, that those changes are always vetted.
So I love that you talked about kind of revisions to privacy policies and contradictions. And I looked at the titles and companies of folks here. We've got CEOs, we've got general counsel, we've got product managers, we've got a few developers. So kind of with that audience in mind, what would you ask? What guidance would you give to those folks in thinking about how that interaction should work to the benefit of schools? What should a developer be thinking about? When should they be reaching out to their general counsel? When should a general counsel be meeting with a product manager when they're thinking about changes in developing EdTech products and how that relates to the privacy policy?
Absolutely. It has so critical to have an open door between developers, the leadership of the organization, and the legal counsel. Just to put it in perspective of education, I don't expect my teachers to be cybersecurity experts and data governance experts. That's not their job. Their job is to educate my students, nurture them, ensure that they're safe, and gain student or success and improvement and growth in education. My developer's job, right, in an organization, your developer is to create a product and to constantly improve your product, look at new opportunities for them, and just continue in that development. They are not data privacy and security experts all the time. You should have some on staff, and that communication should be frequent between both organizations or both departments, including your legal counsel. Oftentimes, I think our programmers or developers make change, but they don't understand the impact. And if we have open lines of communication, then those changes, all of that change management process can lead to, oh, we need to revise this. We cannot do that. So on your developer side, anytime that there's a change to what data you're collecting, how you're collecting data, or how you're using the data you collect, you should have that conversation. On a legal side, anytime you're making changes to privacy policies or what you're doing with data, you should have conversations with the developers and with the leadership to make sure that everybody is on the same page. It is incredibly important that that conversation, that communication is frequent, and not only when you think the change is going to make an impact, but anytime there's a change.
And I think my last question, and I think this is nobody's surprise because it's all we seem to talk about these days, is turning to the topic of generative AI. And yes, it comes up in privacy policies. We recently saw an example that Zoom had changed their policies briefly to add language around generative AI. They added some additional clarifications, and it's not something that is being done in the EdTech space. But in thinking about new technologies, it's always useful to kind of think about, like, what makes this different? What makes this the same? And talk us through how you think about that and how it might apply to generative AI, especially in privacy policies.
I'm going to go right back to that fundamental of anytime we change the data we're collecting or how we're using that data or what we're doing with it, we should be looking at privacy policies in our contracts and our current agreements. I know as a district, I limited the scope of what a company could do with my data to serve that educational purpose that we identified in the scope of work for that product. If you're adding a completely new feature to the product, that is using data in a different way, then do your contracts even allow you to do that without consent, without creating a new scope of services for that client? And I think that those are really big, important pieces to look at. And then how are you protecting data? When we're talking about AI specifically, we need to start looking at our data lake. Is there a possibility when we are using certain technologies that we have data bleed from one organization to another and accidentally release data that shouldn't be released, or accidentally, produce analytics to one district using data from another district without that being appropriate within the scope of services that were defined? There are some products out there that do that, right? That give you comparative results, and you're authorizing your data to be used in an aggregate form to do that. That's one thing. But as we're changing dramatically what we're doing in our systems level, we have to make sure that we're keeping true to the agreements we signed with our districts with our use and protection of our data. And if that is going to change, we have to come back to the table and have that conversation.
That's great, and I think it's a really important point that I hope you'll get to in the next session, especially around things like data deletion, because I think that's a really important topic. But I did want to kind of close out that question about generative AI and just broadly using data for product improvement. You mentioned one of our resources, which is we have a compendium that I just put again in the chat of state-specific laws, and that's kind of where the activity has been. And they don't always, surprisingly, they don't always line up. So many states have language that says that you can use student data for product improvement. California, for example, probably one of the older student privacy laws, so COPPA, actually says specifically that you can, and that you can only use de-identified data. I'd argue FERPA is probably silent on the topic so far. Wait and see. But I think kind of thinking about it may not be one answer there, and we haven't talked a lot today because of time about state laws. But certainly when I think about privacy policies, thinking about how does this apply in this state, and we work with a lot of different states. So I don't know if there were things that have come up specifically that were state specific that have come up in your work that you want to mention.
That's a big question.
Yeah, sorry. I'll let you cover that one. If you think about it and give you time to mention it with contracts. I do want to circle back because I had promised that I would get to some questions. So we did get a question in the chat from earlier. I answered the one about how does Edmodo impact if the data is not being collected by collected from the student. And I think kind of circling back to COPPA, I think the important thing to think about on COPPA is COPPA applies to data collected directly, and it applies to data collected by commercial entities. So there was a question from one of our attendees that is a nonprofit. So in terms of the letter of COPPA, it doesn't apply to nonprofits. But I think part of this is compliance, but also part of this is trust. So just in kind of closing out, thinking about that question where COPPA doesn't really apply to them, how do you, where do you see kind of the privacy policy serving that role of trust?
It serves that role as trust, right? It serves as what we do. There was a question in chat that talks about language of using school official, but the language in the privacy policy really shows us what you're going to do with the data and what our expectations are of you. And we should also see what the expectations are of schools as far as our data, and we should be using that as the foundation of our trust. And we should be able to trust as a school that that's not going to change. And I think this goes back to the language of we may revise these terms at any time, and which we can't have. If it's supposed to be a foundation of trust between us and you and what you're going to do with our data, if you can change what you're doing with our data, if you can change your privacy policy at any time, how am I going to trust that you are really going to be compliant with what I need you to be compliant with? Or you really have the best interest of my student data at heart? Because I expect if you're going to change what you're doing with my data, that we're having a new conversation. Because that product is not the product I initially agreed to at that point.
And I think for me, when I look at a privacy policy, and when I try and talk to teachers, because the IT department is often seen as the department of no. And how do you shift that to yes, but? And the but is, and to answer Fiona's question about, if the privacy policy says we've been designated a school official, I mean, my question on that would be, how? So do you have a process in place where the privacy policy is public facing, but you only do business, as we will talk about with our next section, on a contract? And then thinking about, so basically answering the question, how does the district say they have direct control? And a modifiable at any time policy wouldn't be one. And then the other question is that FERPA gives parents a right to inspect the data. So the other question would be, how are you as the EdTech vendor facilitating that for the district? So I think those are kind of where I would probably end and transition into the more detailed version of this when we talk about contracts. So thank you so much. And I look forward to hearing you talking about contracts.
Thank you, Jim. So Melissa's going to stay on and be joined by me, and we have well, why don't we start with some quick introductions instead of this is our last session. Our plan here is, yes, we're going to talk a little bit about contracts. We'll spend first half or so talking about some of the issues and some of the things that we've seen in our work. And then we do want to reserve plenty of time at the end for questions, because we are pretty confident this is hopefully going to be the part that you're going to have the most questions about. So with that said, I'll introduce myself first, and how about we go around, each introduce ourselves. So say your name, where are you from? Like, where are you working? And what is your relationship with contracts and EdTech? Like, what has brought you into this? And so I'll model that by starting. So I'm David Saleh. I'm, as I mentioned earlier this morning, that I'm the Director of Youth and Education Privacy at the Future Privacy Forum. I've had that job for the past year. Prior to that, I worked in a couple of different roles in student privacy at the Utah State Board of Education, which is really where I had most of my contracting experience. We were definitely involved with overall state procurement things, that if it involves student data, our team would look at the contracts and make sure that all of the required student privacy language was in there. Vendors would frequently give us red lines, and so we'd have to go and be like, yeah, that's okay, or no, that would cross the line. Our law wouldn't allow that, so you're going to have to go back and change it. But ultimately, these agreements would end up going before our board. Our board was the one that ultimately made all the decisions, was the one that was the final one to sign off on that. Admittedly, we didn't do that a lot because we didn't have students. But we did help our school districts follow our state law. And I'll note that our state law, which was passed in 2017, had some extremely prescriptive language about contracts. That's probably like one of the big things I'd want everyone that's a vendor to know, is oftentimes your privacy policy simply did not contain all the language our state law said was needed in order to be a contract. And so this forced us to do contracts that supplemented language in your privacy policy in your terms of service. So I'll say that also always caused me a little consternation. We were talking a little before about consistency, and it always worried me where it's like, okay, you're signing like a national data protection agreement, but language in it is not, it seems to contradict what's in your privacy policy, which also maybe doesn't match something in your terms of service. And I'd wonder, it's like, well, this is legally sound, but like what's really going on here? We had about 160 school districts, and we ended up partnering, as many around the country have, with the Student Data Privacy Consortium and using the National Data Protection Agreement. This turned out to be extremely popular because, you know, that's the other thing I'd say is our school districts, before we had that, it was just so much work. You know, I just did the math where it's like, just for one vendor, one like an LMS or an SIS, something that is very commonly used, having to sign 160 agreements just seemed inefficient. And let alone, you know, our school districts, it wasn't just one vendor, it was dozens, maybe hundreds, depending on how big the school district was. Our legal requirement for the contracts created a lot of extra work. And so we gravitated very quickly toward the Student Data Privacy Consortium, and just to take advantage of that efficiency. So that is where I'm coming at it from, a little bit different because I know it's at kind of the state level. Why don't we go to Melissa, because I think we know you pretty well from the last 20 minutes or so, but like if there's more you want to add specifically on this topic, and then Rama can introduce herself.
Absolutely, thank you. So I am Melissa. I just transitioned to the role of a privacy and tech leadership consultant in July, but through my 17 years with my school district, I was the one who oversaw all of the contracting for any system that housed data. And it was Raytown, Missouri. So I believe that Jim alluded to Raytown School District in Missouri, just right outside of Kansas City. We had roughly 9,000 students, and 200, 300, 400 applications that we used that collected data depending on the year. And it definitely was a job. And talk about that economy of scale, but also the number and the work. In Missouri, until this last year, we didn't have the Student Data Privacy Consortium. And so there wasn't that contracting vehicle that we used. Instead, I negotiated all of the contracts and looked at privacy policies, terms of service. We took a little bit of a different approach. I had a standard contract that if vendors were willing to sign, I would allow them to sign. It was easiest for me. But if they had their contract that they needed to have signed, then we negotiated from there. But I'm with you, and I saw a lot of conflict between the sales agreement, the contract, the terms of service, the privacy policy, and what they were willing to sign unredlined within my data governance addendum. And so we worked through that. I required every vendor to attach privacy policies and terms of service to the contract, the final agreement, and not just link. Like, this is what we're agreeing to. And we would go through and redline to make sure everything was consistent between those agreements, because it does get really complicated. And sometimes you feel like you need a law degree. And sometimes I felt like our folks with a law degree weren't experts in FERPA. And so then we would have a lot of discussions about how, well, we know contract law, but how does this apply to FERPA then, and what we're doing with the data? Or they didn't understand what was happening with the data within the system, because, guys, let's be honest, our lawyers are not engineers. They don't understand the programming side of it. And getting everybody on the same page, we got to a really great process, but it definitely took time to get there.
Yeah, great. So, okay, like seeing similar things, but different process than I experienced, and hopefully for even a more different process. Rama, can introduce yourself, and yeah, what's the deal with contracts?
So I'm Rima Hawley. First, let me apologize. I have a really bad cold, so I hope I'm clear and you can understand me. I work for the Education Cooperative. We're a nonprofit school collaborative located in Walpole, Massachusetts. I am the director of our Student Data Privacy Alliance. We were an early adopter of the Student Data Privacy Consortium back in 2016. My organization is responsible for helping school districts work together collaboratively to do things together that they find difficult to do on their own because it costs too much money or they don't have the human resources to do the work. And back in late 2016, our member districts identified securing student data privacy agreements with their digital providers as one of those things that was way too difficult and way too expensive for them to do on their own. So they asked us to develop a program to do it for them, with them. So we did. And we have 14 member districts. And we've soon realized that we couldn't sustain a program like this financially unless we open it up to other districts around the state of Massachusetts and charge them a very nominal fee to participate in our program. We did that, and it really shows how schools were struggling with this particular need, because very quickly, many Massachusetts schools joined us. Soon afterwards, New Hampshire contacted us and said, hey, we hear you're doing this. Can we join? Then Rhode Island, Maine, Vermont, and last week, the state of New York. So once New York is fully onboarded, we will be providing our services to over 1,000 districts in those 6 states. We use the National Data Privacy Agreement. Ours is a 6-state, so it covers participating districts in all 6 of those states. A provider need only sign it once, and all participating districts in those 6 states can piggyback on that national DPA just by completing the Exhibit E, the General Offer of Privacy Terms. So this has turned into really a great collaborative for school districts when there's a breach of contract or a data breach. We get together, we help the districts understand their obligations, we work with the providers to resolve it. It's turned into more than just securing signed data privacy agreements and negotiating those with our attorney. It's turned into a real community of protecting student data.
Great. Yeah, thank you. Okay, so good variety in terms of our backgrounds, but all of us working with contracts to some degree. And I think what would be really helpful, and I think we've gotten at it a little bit, so I'm thinking a lot of the participants in our audience right now, they have products that they believe in, that they believe will help kids. They want to get these into schools. And also, I think if you're on this call, you want to do right by privacy. So you go to something, let's say like ISTE, you want to like really publicize, let everybody know, like, here is a product, like, we want you to use it. We have free trials. Like, this is so great. It's going to change things for your classroom management. It's going to change things for your students. And then I feel like we would often at some point get looped in, and that's where, again, it's like oh, you're the Department of No again. And I think we are always like, well, we want to be the Department of Yes, but like we've got some things we have to get in order. So like what do you think an EdTech vendor, what would you like them to know? And one of the things I'm thinking of is just like, what does the process look like on your end? School systems, school districts, they're the government. We have lots of processes we have to follow, lots of people that have to sign off on it. And maybe a good side question with this is just simply like, is there a world where teachers are allowed to be the one, as Melissa already knows where I'm going with this and is shaking her head, where teachers are the ones who are authorized to give the final sign off? Because like I said earlier, like in my working for the state board, like it was the state board. We prepared everything. We did everything in our procurement law. We covered everything that needed to be in our privacy law. And ultimately we would present all that to our state school board, and they made the decision. We weren't advocating for it typically one way or another. Maybe other people were. But how did it work in your individual areas? What does the infrastructure look like? Like what could they expect if you can peel behind the curtain a little?
Okay, I will start, and this is one of those soapboxes that I could talk on forever, so I'll keep it short. But specifically in the state of Missouri, a contract isn't a valid contract for a school district unless it's approved by the Board of Education. I'm gonna let that sink in real quick for all of our vendors, because if my district board does not approve that contract, that is not a valid contract. And so a vendor allowing a teacher to sign a contract on behalf of the school board or on behalf of the school, if it doesn't go to the board, then it's not an approved contract. And then how do you know what your contracts are approved or not approved legally? What will hold up, won't hold up if there's some type of disagreement. I always tell people a contract really only matters when something's not working right and we have to go and say there's a conflict, there's a breach of contract, and we're trying to make things right. Like that's when the contract really matters to all of us. I'm not saying that the contract itself doesn't matter, but that's when, you know, the rubber meets the road when it comes to contract. So if something happens and you're having to go to a district and you've accepted a teacher signed contract and they're saying, well, that's not a legally binding contract for us, we didn't take it to board. I don't know if all states are like that. I know many states are like that I have presented in, that I have done training in, that the contract has to go to the board. If the state's not like that, and many districts are like that, some districts will delegate, maybe smaller districts, to a teacher level, but not all. And so my recommendation to especially startups and to any ed tech provider is don't target the teachers, because oftentimes they don't have the real authority to sign a contract. And you're either knowingly or unknowingly asking them to violate board policy or state procurement policies that way. To your mention of pilots are still collecting data on our students. I don't care what you call it. You're collecting educational records. We're using them for some type of analysis, some type of educational purpose. And they have to have a compliant contract in place before you can begin a pilot. Calling it a pilot doesn't get you around FERPA. So that's also another thing that's really important to note, is like, just because you're piloting something doesn't mean you get to bypass that whole process of ensuring a compliant contract. That's still required even at that entry level, just being, unless you're piloting with completely fake data, which I don't know many districts who do that.
Yeah, thanks. And in the Northeast, how does it work?
So in most of our districts, not all, but the majority, a digital tool is blocked from the network unless a signed data privacy agreement, the National Data Privacy Agreement, is placed. So the process looks something like this. A teacher will put through a request to use a digital tool. And that request will go through a vetting process, the curriculum director, budget, technical support, those types of vetting. And if the person in authority at that district decides that, yes, it meets all of our internal vetting needs, that request will then come to me, and I will try to secure a signed data privacy agreement for that tool on behalf of that school district, and then ultimately all the districts in those 6 states. So as far as the authority to sign, each state and each district has a little bit different policies in place for signing, but the appropriate people in those states are signing those data privacy agreements and the correlating Exhibit E's on behalf of their districts. It's a very automated process. And so if a digital provider should receive a DPA signed through me or through the Exhibit E process, it's appropriately signed, at least from our 6 states.
Thank you. Yes. Okay. You all answered it more or less the way I expected. And you know, I think that's just like contracting basics, is ensure that the person you're contracting with is legally authorized to sign contracts on behalf of the organization they claim to represent. I feel like if you're not doing that, like the teacher is probably, again, being very sincere, but like that feels almost like a scam almost if they're representing themselves as something that they can't do, and then that contract isn't valid. So it does make me wonder though, because you did mention, Rima, that there is a mechanism. So if you were marketing your product to teachers, because I do feel like that does become the challenge. Like they're the end users, they're the ones you want to use it, but they're probably not the ones who are authorized. That there is at least a mechanism wherein they could go to ISTE and be like, this sounds like a great product, and that they can then request it and get it ultimately approved. Was there something similar that you had, Melissa, in your district, where if somebody really wanted a product, how did they get it on your radar? And also, like, how long could they expect for it to take?
Absolutely, there's a process. If we don't have a process, then we're not there for what we need, which is to help our teachers do their job. And we have to have a process. We have to make it as easy as possible. We had an online form that they submitted. It went to curriculum instruction to make sure that the product aligned with our adopted resource or our adopted curriculum. And then as soon as that happened, it went to my team. The initial process, if everything went smoothly, we could be at a week and a half to 2 weeks. However, how long does it really take? A lot of that depended on the vendor themselves, because we negotiated a contract if we were sharing data. And it depended on how fast they responded and if they had to involve their legal team and what that back and forth looked like. So we would be anywhere from 2 weeks to 6 months on a resource adoption, depending on the scale of the resource and how much back and forth and what the response rate really was from the vendor, because at the district level, our internal process to start that was really fast.
Okay. And yeah, it's tricky because like Melissa's in a district and like, yeah, it's basically the whole Northeast right now. Although like what kind of timelines are we looking at for in your consortium?
So it really depends. If we're renewing a data privacy agreement that has expired after its 3-year term, because we're using the national data privacy agreement, in many cases, I'm approaching a provider that has already signed that same national agreement with other states, California, Oregon, Texas. And the standard clauses are identical from state to state. So when I approach them, the only thing they need to review are I feel like I'm talking only about exhibits today, but our exhibit Gs, which capture the unique state laws for each of those states. So my national DPA has 6 exhibit Gs. So if it is someone that's just renewing a DPA with me, it can just take a couple hours. They've seen it, they've reviewed it, they know they can sign it. So I might receive that data privacy agreement back from that provider within just a couple hours. In other cases, I might be the first in the country to approach a provider with the national DPA. In that case, they need to spend the time really reading it, understanding it, getting legal counsel, getting the technical people involved to make sure they meet the technical requirements, the minimum data security requirements, the cybersecurity frameworks. So it can take a while, and we appreciate that. We don't want a provider to sign an agreement without fully understanding what they're committing to. So yes, it might take a week, 2 weeks. Where it really takes a long time is if the provider feels the need to submit red lines, to propose modifications to the standard clauses. So that can take a very, very long time, months, even a year, with that provider's attorney or attorneys and our attorney, the back and forth. And that's difficult for the teacher that's sitting in that classroom desperately wanting to use that tool. But it's a necessity. Like I said, most of our districts, if you don't have a DPA in place, the tools are blocked. The teacher can't get at it. So it really varies depending on the situation and the provider.
Yeah. So that makes me wonder, what can be done then to speed the process along? For example, if the provider wanted to be really helpful and essentially just like create lots of places where you could just click and be like, yes, I agree, and the click-through agreements. Like if you saw one of those, what is typically your reaction?
Me?
Yeah, to both of you.
Okay, so I don't think many users actually read what they're clicking through to agree to. So I don't really want to make the national DPA a click-through agreement. We really want it understood. And Melissa talked about trust earlier, and we're trusting that the providers have really read this, really understood it. They're going to comply, and that our students aren't going to be at risk. So, yeah.
And can and I might be hitting on something that got posted in Q&A, but I think that if the district or the consortium, the state, whoever's initiating that on behalf of, the customer, if we are reasonable about our requirements and our requests, and we're only, we're ensuring compliance with law and reasonable with security requirements, and we can articulate the reason why, then we shouldn't have to take 6 months to a year in that process. And I have found, as long as the company is reasonable and they understand why. Personally, what took the longest in my contract negotiations was terminology over liability in the event of a data breach, and understanding what the company's cybersecurity and data breach insurance should cover, and what I as a district should be responsible for in those pieces. That typically took the longest amount of time because everything else fell in compliance with law. And if there was a little bit of a disagreement or a red line, we are able to go back and forth. So with the follow-up on what Irma just said, though, is that as we're negotiating or renegotiating and recertifying agreements, I think it's that trust piece, that when I say that data governance agreement, addendum, whatever we're calling it, data privacy protection agreement, whatever we're calling it, when both parties sign that we hold to that, and future contracts don't negate that. And that was the problem that I found, is that the next sales order that would come in, even if I had a master agreement with the company, the next sales order that came in for my salesperson didn't link back to that agreement, but it linked to an updated privacy policy in terms of service and new terms that they wanted me to agree to, and not the ones that we had already negotiated and that we were currently under. And that goes back to that trust and making sure as an organization that those pieces are there, where we're not negating all of our hard work with this new sales order that's coming through.
Excellent. And it does make me wonder, are there specific terms then in the agreements? Because it sounded like one of the things, if you give them the national DPA or your district specific one and said, here it is, they're going to come back and redline it. There's going to be issues. I know in the case of Utah, like one of our hardest requirements was our state law required a right to audit clause in any contract that involved student data. Didn't matter what it was, if it was a thousands of dollars contract, if it was a free thing that was supported with advertising, didn't matter, had to have that term in there. That is never in anyone's terms of service or in their privacy policy. So we always had to negotiate. And it was frequently one that the vendor would cross out and say, like, we don't want to agree to this. And we'd always say, like, it's in our law. Like, the school district does not have the time or money to audit you. They're probably not going to do it. You don't need to worry about how invasive it will be. We struggle to find out, like, what the right language would be that would make everyone happy, knowing that at the end of the day, it was a legal compliance thing. It had to be in the contract. I think data deletion, that came up a little in the conversation with Jim a moment ago. That was the other one that was always really hard. And also, and I think this came up with some recent FTC things. Like that was with Amazon Echo that the FTC found with them in COPPA, where it's like COPPA requires, if you're collecting information from a kid, you can't hold on to it indefinitely. You have to delete it after a reasonable period of time. we can disagree about what's a reasonable period of time. What's a reasonable period of time to notify a school district after you've had a data incident or a data breach? Those are the ones I'd often see where it's like, let's change 72 hours to, like 1 week, something like that. What were the things that would often be redlined, and that, because that always, I think, caused the biggest headache, and like, where was their flexibility, and where was it just at the end of the day, like, look, I can't budge on this. This is in the law.
For us, in Missouri, we didn't have a lot of law, except for we do have to provide notice if there is a breach of educational records, of education data of even just one student. So one of those pieces we went back and forth was defining what data constituted a data breach and what data constituted an educational record, to make sure that, because some companies define a data breach of just what's federally PII, and making sure that they're notifying us of a breach of any identifiable information. That went back and forth a decent amount. What we considered appropriate de-identification. Sometimes we would go back and forth about sample size and what appropriate de-identification was. I did talk about the liability in the event of a data breach. And then the last one is our auditor requires us to keep an inventory of all of the data in our system. And so we had a lot of back and forth about data inventories. Not a data dictionary, but a data inventory, which goes back to the conversation I just had with Jem about if you're changing the data that you're collecting or how you're using it, what you're doing with that data, that can impact the data inventory that I'm legally required as a district to maintain. And so just understanding that, we would get a lot of pushback on the data inventory as well. Yeah.
Oh yeah, we had the similar thing in Utah. It's a challenge. So I want to open it up to some of the audience questions. So going to start with one that's in the Q&A here. So what is your view on privacy policies versus data exchange or similar agreements? So I'm going to see this as, kind of, we had the discussion before, and, certainly COPPA expects certain policies and, certainly notifications to the school. And we're talking about either district specific or national agreements. And they continue, in my experience, so many schools, especially in California and New York, require separate data governance agreements, which seemingly makes the privacy policy a lot less important in the grand scheme of things. So like, what should a vendor do with this? Like, should they, as an example, I have seen some vendors have a copy of the National Data Privacy Agreement, and they say, this is now our privacy policy. You work with your state or whoever in the consortium you're doing it with. We also talked a little about, it becomes concerning when the privacy policy says one thing and they're so willing to sign a contract that says the other. And then we're like, well, what is your actual business practice? What do you do? So what do you think? What would be most helpful for our audience here, and what they should focus on?
I think you still have to have a privacy policy on your public-facing website. Like you're required to do that in most cases anyway. You need to have the privacy policy on your public-facing website. However, that doesn't have to be the privacy policy that you're using when you're contracting with schools and providing a service outside of what's publicly facing to, everybody in the world. And so my master contract negated a company's terms of service and privacy policy. And we agreed just to those contract terms that were in that master contract. I would prefer as an entity to not have to have a privacy policy. I had contracts that were like 40 some odd pages because I had terms of service and privacy policies and data governance addendums and then their contract language and their sales agreements. If we could make that more manageable and eliminate one of those documents in the contract side of the house, I was happy to do so. And that was personally in that side of it.
Well, the national DPA does have a clause that states that the terms of the national DPA supersede the privacy policy in terms of service of the provider wherever they might conflict. So it does give the national DPA control of the relationship. But I've found recently, this is becoming more common where the provider will say, we need you, everybody that fills out an Exhibit E to subscribe to this agreement, we need you to provide the domain names of the school and then we will restrict our product to comply with the DPA. So for example, let's say they use targeted advertising. They would then take the domain names from the schools and restrict access so that those schools aren't being given targeted advertising. And that's not the only example. There's other ways they restrict the product to comply with the DPA. So it kind of, if your privacy policy says one thing and you sign the national DPA, I think that's one way that providers are finding that they can comply. Maybe they don't want to make the product that's out there in the public realm comply, but they do want to comply with those schools that have signed the national DPA. So that's just an interesting kind of new development that we see kind of becoming more and more common.
Interesting. I'm going to take another question. So going back to when we were talking about who approves, and that really it sounds like in most cases, like the Board of Education, or certainly not just a teacher, though again that might vary because certainly in rural areas a teacher might also be essentially the chief technology officer for the district. I definitely had that in one of our rural areas in Utah. But so is that Board of Education approval required for individual contracts, or and this again might be better on the consortium side, could they just approve a template agreement like the NDPA? So in those cases, are they still going in and like approving hundreds of NDPAs, or do they just do it once where they give a blessing to the master sharing agreement language? Or I think even Melissa, you mentioned in your district, you had your template. Like even still, like if they agreed to it with no red lines, could the board have just blessed the agreement and said anyone who agrees to this, they're good, and move on? What could we expect in each of your areas?
Well, for our states, each state is different, but in each state, the national DPA and that state's accompanying Exhibit G that it has the state laws has been approved by either the state's privacy officer or someone at a very high level in that state. But still, each state and each district has its own signing policies and procedures. So it just is a matter of, in most of my districts, a technology director is approved to sign the National Data Privacy Agreement, with or without red lines that have been negotiated by our attorney and approved by our attorney. So it just really depends on, so that's the National Data Privacy Agreement. I'm sure that is not true with license agreements or service agreements or any other type of agreements in those districts. This just happens to hold true for the NDPA.
And a contract's a contract. So each one is an individual contract. And so every contract has to go to the board. Now, typically they're going to go to the board under a consent agenda item. And so we might have 20 that they're approving at that meeting. We're not discussing every single one, but every one does go for board approval. For many of our contracts, I can still sign those and enter into them, and then they just go to the board meeting for the formality of becoming a legitimate contract, but I have authorization to sign and commit the district to that. They still have to go for board.
Yeah, interesting. So again, like, and this is one thing that would come up. I felt it a lot in the state office. I'm sure both of you feel it in your respective areas as well. But like, education in the United States is very local control. And what that means is, like, I imagine even in like Metro Kansas City, you could be going to a different district that wasn't Raytown and might be a totally different process. But I think the big takeaway is just knowing that, like, if you want to do business with schools, you need to figure out who is the right person who can do the contracting. We have some things like consortia, or obviously it sounds like your one, the TEC is growing, having added on New York. And that's probably the first thing, is just to figure out, you know, well, what is the market? Where do we have to go? And there is a question, and it is just specifically for REMA, so I'll ask it there. You know, New York is joining TEC. How is that going to work? Does this apply to the BOCES? How does this affect the New York Ed Law Agreement and Parent Bill of Rights, which we have been signing with New York districts? Because yes, New York is another one of those that has a very specific law that says your contracts have to say all of this, or they are not legal.
Right.
So, you know, in New York, since they're joining on, you're probably thinking about them. What can you share quickly about what vendors could expect there?
So we just started with New York last week. We're in phase 1 of a 3-phase rollout. So yes, the BOCES and the RICs will be involved and participate in our program. The way the National Data Privacy Agreement is structured is in New York's Exhibit G. There are other exhibits, and I think it's Exhibit K or J, where the New York either BOCES or an individual district will supply their Parent Bill of Rights and their policies with links to the provider in that originating data privacy agreement. All subsequent New York districts that subscribe to that data privacy agreement through Exhibit E, on that Exhibit E will be links to their Bill of Rights and their district policies. And then New York law also requires that you, the provider, supply who's ever on the DPA, if it's a BOCES, if it's a RICS, or if it's a individual district, with links to your data security plan. So there's an exhibit where you can put that link in the National Data Privacy Agreement if New York is the originating district. So we've been meeting with New York since early springtime. This is really well thought out and organized and planned. And I really think providers will find it easier to do business in New York from sign a data privacy agreement standpoint. So by phase 2, we should have 700 participating districts with tech. And they'll be the districts that have some sort of relationship with the 37 BOCES. So I think phase 3 is, what about the other, I think maybe it's about 100. What about the other 100 New York districts that don't have a relationship with the BOCES or the RICS? So we'll figure them out when we get to phase 3. I hope that answered your question.
Well, it sounds like we'll see. It's growing, and like New York is obviously it has its own educational infrastructure, and yeah. So hopefully more to come as you continue rolling things out with them.
I would just add, we've done this all at the direction of the New York State Privacy Officer. So it's really well done.
Awesome, excellent. So we are kind of coming toward time here. There were 2 questions, and I was like, oh, what do I want to do with these? Like, I'm not really sure what to say, but inevitably, since, like we were saying, education is very local, we're going to have school board members. You're going to have members of the legislature who are going to propose certain requirements that, we working in privacy or security might look like and be like, what are you hoping to accomplish with that? The one in the question was, like U.S. hosting, like they want that in the contract. Or another question said, it sounds like Illinois is, I don't know their specific law. None of us work with Illinois, so I'm not quite as sure. But, certainly in the case of Utah, we experienced it with, like, we had this right to audit requirement that I even asked the senator who required it. It's like, what are you hoping to do with this? Like, the school districts, you didn't give them money to do audits. They're putting all of their effort into getting these words into a contract that, like, I've spoken with them, and they say, like, if something went wrong, would you audit them? And they say, no, we just quit using them. And, he still felt like it was important that if something went wrong, that we at least had that as an option. So I tried to get it removed and never was successful. But, like, you know, if there are these things coming up, and maybe we don't need to speak to those specifically, though I do see Melissa did add some stuff in there about US hosting, so do check that out. Like if there is something that you just can't seem to make work, you know, like some term where the person in the district or the state is like, we have to have this, and you're like, this is crazy, I don't understand what this is even for. What do we do in those cases? What would you recommend for the vendor? Because I feel like at some point our vendors would just say, take it or leave it. Like, we're not going to negotiate this term. And then you lose a great product. Is that what is best? Or what do you think?
There's very few terms that we haven't been able to negotiate successfully with providers. And definitely the audit section is always a little tricky, but we always get there with a little massaging of the words. The biggest one now that's been coming up recently is providers wanting to use de-identified data with third parties outside of their organization or their sub-processors. And that's a drop dead for us. We won't allow that unless they tell us the third party that they're going to be sharing it with. We approve it and write it into the data privacy agreement.
Interesting. Melissa?
I would say over my 17 years, there's less than 10 vendors that we couldn't get to terms on. And a lot of it is understanding both sides and coming up to something that's mutually agreed upon. There's some language though, that if it's state mandated, that the company just has to decide, are we willing to lose business over this? And if it doesn't fit your business model, then that's your choice, and it's okay. It's okay if the school doesn't want to and you can't support them and you guys just part ways. If that fits and that makes the best business sense to you, because there might be some requirements that an individual district or even a state requires you to meet that maybe is too costly for you to implement right now, and you come back to it or you work it in later. I just think that you have to talk about the risk and the business decision behind it and be fully transparent with your district. Don't waste their time. I had a vendor I went back and forth with for 2.5 months with red lines that they kept just manipulating language because they didn't want to agree to something. And finally, they just said, it doesn't matter how you're getting at this, we're not going to agree to it. I'm like, I wish you would have told me that 2.5 months ago. Like, if that was a hard no for you, just be transparent about it. Just like hard no's, I'm transparent about from the beginning. If you redline it, I'm saying, sorry, this one's not negotiable. And not every business relationship is the best choice. So I think sometimes it's just okay.
Mm-hmm. Well, and I would hope with some things, you know, one of the reasons I wanted to come and work for the Future Privacy Forum is I liked where it was situated, where we have relationships with the districts and with policymakers and with EdTech vendors. And I think one of the best things to do is, you know, have that conversation about the issue and be like, you know, what is the concern here? Like, because again, I am coming at this optimistically that anyone who is on this call wants to make a product that is great for kids, that will make teachers' lives better, help kids learn, and also wants to do right by privacy. And just sometimes we can, you know, not always see eye to eye. And that's where it's like, well, let's talk about it. What is the concern? Why this requirement? And for example, as we were just talking, I got a question here from Laura. So what's motivating the concern about sharing de-identified data? Is it about the integrity of the de-identification process? Which I'll say that always gave me pause when they said, oh, it's de-identified. And it's like, can you tell me more? Like, did you just strip the names off and nothing else? Because that might not really be de-identified. I think we've got like a few extra minutes, so I do want to allow you both to address that question.
Well, for us, that is a concern, absolutely. But we also think that this isn't allowed under FERPA. I mean, you can talk to a dozen different lawyers and they have different interpretations of FERPA. But we believe that this is still our student data, de-identified or not, and only we can share it with the school official. And that school official cannot give that data or sell that data, even if it's de-identified, to a third party without our written consent. So that's our attorney's position on it. And Steve Smith agrees, a lot of people do. that have looked at that really do agree with that. But of course, the concern about how fully is it really de-identified is of a concern.
And I'll echo that. It's, what are you doing with the data? What is the purpose of it? Because we're very clear in our agreements that you can only use the data to provide the services to us. So then why are you sharing it with others? And what's the intent, and how are you de-identifying? Like, really, are you de-identifying it? And that's why my contract's always defined with that appropriate de-identified, or what appropriate anonymous data looks like.
Yeah, I think if you look at the language in the school official exception, they have to be providing a service that the school would otherwise use its own employees for. So that's the first question I'd have, where it's like, well, would the school be de-identifying it to just share with things that don't have to do with this actual educational task? And then there's the direct control issue, where it's like, yeah, this is the whole purpose of the contract, right? Is for the school to be able to say, we are contracting with you, we are giving you student data, but for these specific purposes. And if you're doing it without the school's consent, like was said, then like, is it really still under the direct control? Did they authorize you to do that or not? Real quick, so we're going to wrap up here, and final thought, and this is one I wanted to leave it with. What is the vendor like that will just make your life the easiest? What is there a packet? What materials? What could they give you that would just make you say, oh, I love this vendor already? What is the best thing they can do? Because again, like I said, I think we all want to do right by privacy. How can they best show it? What do you want to see?
I want to see not my salesperson negotiating the contract with me. I want somebody who really understands what FERPA is, and for them not to tell me that they're not collecting. I don't know how many people I've said, well, we're not collecting educational records, when we all know that they are. So understanding that, COSN has recently released the K-12 CVAT, which is a nice, if anybody works in higher ed, there's the CVAT there that shows, cybersecurity, data privacy, the technical requirements, and what they're doing. And so if a vendor has that, it can show us, hey, look, these are all of the practices we have in place technically to make sure that your data is secure. I think that takes off such a load on the IT team that we can focus on a few other pieces of the contract, and we don't have to worry so much on the technical side because we get the score there with the CVAT. I can put the link. Oh, Jim's on it for me. So I think that right there is a really great step.
So I would say a couple things. Number one, signing and understanding what you're signing, the National Data Privacy Agreement. And I would also say the Student Privacy Pledge, and also joining the Student Data Privacy Consortium as a provider member and work together with us in this privacy realm.
All right. I think good final thoughts there. We did have a couple other questions come in, but we're so close to the hour. We can maybe address those in the chat quickly. Or yeah, one was, what is the URL to sign up as a vendor to the DPA that's used in the 6 New England states? It's Okay. Thank you, everyone. I'm gonna thank you to Rima, thank you to Melissa. I'm gonna pass it over to Alexa to close us out.
Hello, everyone. Thank you so much for joining us today. And thank you also to our wonderful panelists and speakers. We are so fortunate to have such knowledgeable people speak today, and we really hope that you found our sessions useful and helpful. We really look forward to the opportunity to be able to speak with you and about the issues and compliance in this space, and to help provide tools to navigate it. And we want to make sure we're doing that well. So be on the lookout for a follow-up email after this event. There's going to be a short survey in it. These surveys are really important to us because we want our content to be as relevant and as helpful as possible. So taking 2 minutes to provide us with your feedback helps us do